Yesterday, I talked about the third hearing of ADOR's case versus Danielle and Danielle's mother, Miss Mo, and Min Heejin. Now I have more details on what ADOR presented, including dates, the details of the Chinese contract, other recordings, also Danielle's side, what they actually said, and what the judge also said. Let's begin because it's pretty long. Let's start with the side of ADOR. ADOR submitted an audio recording dated September 2, 2024. And in that recording, they said that it proves that it was actually Min Heejin who pushed the five members of Newjeans to do their YouTube live stream. In that live stream, if you would remember, they demanded the restoration of ADOR's previous management structure and also Min Heejin to be reinstated as the CEO of ADOR. Also, they said that Min Heejin actually continued working with Newjeans behind the scenes. They said that she personally planned and directed Newjeans' independent activities after the members began promoting under the name NJZ. And she was actually involved in NJZ's profile photo shoots, music production, planning the group's now infamous appearance in Complexcon Hong Kong, choreography, merchandise production, and styling. Now, this seems to contradict what Newjeans implied in several interviews when they said that they would actually want to work again with Min Heejin if they ever get the chance, implying that they weren't working with her then. Okay, this is one of the interviews where they actually said that Teen Vogue published the interview. Now, ADOR also submitted a recording dated March 7, 2025, and they said that this recording actually shows that Min Heejin asked the legal team of Newjeans to add in their argument that, and I quote, "Eyelid's manager mocked us through words and actions." If you would remember when Newjeans asked for the termination of their exclusive contract, and when they were giving out interviews, they stated that one of the reasons they wanted out of ADOR is that they were not being treated well, they were getting bullied, and one of the substantiation is that one eyelid manager ignored her and asked eyelid manager to do the same. HANNI even went to the National Assembly to talk about being bullied in that specific instance. And also, when Kakao Talk messages of her and Min Heejin were revealed, showing that it was actually Min Heejin who suggested that that happened, and that at first she actually said that no, it didn't happen that way. She posted this message on Instagram stating, "How can you take one part of a conversation and shift the meaning of it to benefit your point of view when I was the one who wrote that message, whilst you present yourself as company that wants the best for us?" Now, the court later concluded that based on the CCTV and also the Kakao Talk messages that were submitted as evidence, the phrase "ignore her" actually originated from Min Heejin and not HANNI. Just to clarify, Min Heejin was the one who planned it, but HANNI agreed and proceeded to do what Min Heejin actually wanted or proposed. Next is the Complexcon fees. They said that the fee was actually sort of divided into two: 350,000 for the members, their performance fee, and then there's 500,000, which is the consulting fee. And they said that when viewed alongside other pieces of evidence, the consulting fee appeared to be money intended for Min Heejin, but was bundled with the other members' compensation because of concerns about how it might affect future litigation. ADOR argued, why is the consulting fee more than the compensation of the artist? Why is she earning more than the artist? What's the purpose of this? Okay. Now, also, ADOR presented an email that was sent to Complexcon dated March 21, 2025. And that in that email, she instructed the staff of Complexcon to prevent ADOR employees from accessing the Complexcon venue. If you would remember, Complexcon, um, this was a day or two after the injunction that sided with ADOR, limiting the activities of Newjeans to ADOR. And at that time, ADOR had dispatched employees to Hong Kong stating that they were going to support the group's performance despite the ongoing legal dispute. But according to the email, it was actually Min Heejin who instructed Complexcon to prevent the staff of ADOR to reach Newjeans. Also, ADOR submitted an audio conversation between Min Heejin and other staff member dated February 2 and February 6, 2025. And in that conversation, ADOR instructed staff members to keep all of these activities confidential until September because it could affect the ongoing lawsuit that she was going through against Hybe and ADOR. And ADOR argued that this conversation suggests that Min was attempting to conceal her involvement while making the activities appear to be independently organized by the members. And they also allege that Danielle's Singapore photo shoot proceeded only after receiving Min's approval. Also, according to ADOR, this demonstrates Min's continued behind the scenes involvement in planning the members' activities. Okay, next, let's go to the Chinese company contract. According to ADOR, the discussion with the company, OOA is what they call the company, with the discussion with the Chinese company actually began as early as September 2, 2024. And it was actually initiated by Min Heejin even before the parents of the members were made aware of it. According to ADOR, Newjeans entered into a 9-month exclusive agreement and they signed it September 25, 2025, roughly a month before the first instance ruling in the main lawsuit over the validity of their exclusive contract. I know you're going to be curious about the date. So they signed the contract September 25, but the injunction decision favoring ADOR that happened March 21, 2025. And then the first instant ruling upholding the validity of the exclusive contract that was handed down October. So the signing of the contract happened in between. Okay. Now, ADOR said that the agreement would automatically renew unless either side objected. And it also included a provision that requires Newjeans to report activities of and information of ADOR to OOA. Okay. So they said that this is also the same company that offered to buy ADOR from Hybe. So I said last week that they offered to sell back the contract of Newjeans yesterday. I said yesterday that they offered to sell back the contract of Newjeans to ADOR. That's not what they wanted. They wanted to buy ADOR from Hybe. Also, they said that the contract included another clause stating that Newjeans need to report activities of and it included a provision in their contract that said that Newjeans are actually required to prevent the sale, lease, or transfer of Min Heejin's share in ADOR. This was actually confusing for me because Newjeans themselves don't have any power over the share of Min Heejin. So what I'm about to, because I tried to interpret it, this is not a legal advice and this is not my interpretation and this is not on any of the newspapers that reported it. This is just my interpretation. This part, I think the Newjeans were contractually obligated to do things that could prevent the sale or transfer of Min Heejin in ADOR. So that could mean they will object to any kind of transaction or support Min in any litigation or refuse to cooperate with any transaction that could facilitate a sale. Again, that's just my interpretation. I'm not sure if I'm correct. Okay. They said that let's go back to the contract. Okay. Now, Min Heejin worked with after they lost the injunction, after Newjeans lost the injunction, Min Heejin instructed the parents of Minji and Danielle to make demands that ADOR could not possibly accept and to record the conversations. If they are going to have any kind of conversation with ADOR, she instructed them to record it. And they said that Min Heejin, again, planned all the activities, independent activities of NJZ or Newjeans, and that included music production, Complexcon, profile photo shoots, and all of the activities of Danielle. Okay, so it turns out that this, everything that they were wearing, the music that they performed, and even the choreography, that was all Min Heejin. Okay, now, Adore also submitted conversations dated March 25 and 26, 2025, shortly after the court granted Adore's injunction on March 21. According to Adore, the conversations between Min Hee-jin and the members' mothers or parents, and also the attorneys, showed that Danielle continued pursuing independent activities while excluding Adore. Okay. Now, let's go and talk about Danielle's side. They During the hearing, Danielle's legal team objected to Adore coding conversations and contracts directly during the presentation. The defense argued, that is the side of Danielle, they argued that although the court had agreed that the documents themselves would not be publicly displayed, Adore was still reading portions aloud, making it likely that the reporters will be publishing this to the public. For context, there were a lot of media people present. Daniel's attorney requested and refute references to be, and they requested that future references be limited to what was necessary for the judges, then and limit the direct quotations. Now, the judge actually, Judge Nam In Soo, echoed that concern and reminded Adore's legal team to focus their arguments on the court rather than addressing the large number of reporters present. Now, this translation, this transcript was actually given to me by a Newjeans fan base. Okay, so they were the ones who transcribed this part. All right. Now, Newjeans said, Danielle, the side of Danielle said that there were no final products or compensation. And that meant that they did not breach the contract. There were no contractual violation because there was no payment. The final product was actually not released. Okay, now for context, the same judge Nam In Soo is actually the one who ruled in favor of Min in the put option case against Hybe, and according to the judge in his decision, it was because she did not complete the takeover of Adore and she wasn't able to bring Newjeans out of Adore. In his decision, he acknowledged that she made attempts to actually take over Adore and leave Hybe to try and pull down the value of Hybe. But because she wasn't able to complete it, then it's not a breach. And so that is a precedent, and it seems that this lawyer is using that precedent that this same judge set to argue his case. Okay. Next, the Adore, however, rejected that argument, stating that regardless of whether compensation was received, these activities violated the fundamental purpose of the exclusive contract, which prohibits entertainment activities that is not under or coursed through Adore. Okay. Another thing that the side of Danielle said is that Adore is just exaggerating the case. Danielle's legal representative rejected Adore's argument, saying that these were not Danielle's independent actions. They were actually actions involving all members. But Adore is speaking as though Danielle alone committed major contractual violations, but many of the issues it raises apply equally to all the Newjeans members. End of quote. So they're saying that they're targeting Danielle because she's not the only one who signed these contracts, who agreed to all of this. So this is just targeting. They're not being fair. Okay. Now, another thing that Danielle's side said is that um, Adore did not give Danielle a chance to rectify the mistakes. So the lawyer said that they sent a registered mail. After that, they terminated the contract. It seems like from the very beginning, according to the lawyer of Danielle, they were actually hell bent on just kicking her out. Okay. Next, Danielle's lawyer also questioned Adore's damages calculation. So the judge noted that Ador's damages claim appears to be based on projected revenue from Danielle's expected activities in 2025 and asked why would you need an appraisal expert if the company already have the books for 2023 and 2024 and 2025. You should have this. Why are you asking for a professional appraisal? And the judge also questioned whether the calculation depended on assumptions about Min Heejin's involvement and whether all the members would actually continue promoting together. He suggested that those factors could make the damages estimate speculative. Daniel's legal team said that ADOR's projections for the damages were hinged on two things. One is that Min Heejin would have remained involved with the group. Second, whether all the members would have continued promoting together. Because those assumptions are uncertain according to the defense side, then the calculating damages is not a straightforward thing. So the judge observed that the plain this is Ador. Ador appears to have presented a fairly specific plan for the appraisal, but it assumes that the performance achieved in 2023 would have just continued in 2024 and 2025. Then, if that's the case, wouldn't it be any different for if the company would just calculate the amount themselves? You already have the books for 2023 and 2024. Why would you need an appraisal? You already have it. Okay. The other thing is that the legal team replied and said that if you are just going to base it on the income of 2024, 2023, and 2024, then you don't even need an accountant because you already have the books. Now, just for context, Adore is actually requesting to get a professional third party appraisal expert to calculate the damages. And the side of Danielle said that this is just going to drag the case longer. Now, the judge acknowledged that both sides had reasonable arguments and he summarized it. He said that Adore argues that damages should be calculated using company's 2024 business outlook and projections, while Danielle's side argues they should instead be assessed using information actually available in 2026. So the judge said that he remained unclear on whether the issue should be decided by an accounting expert or another specialized appraisal institution or through consultation with an outside expert. He did indicate that the court had not yet reached a conclusion on that issue. Okay. Now, next is that he set the deadline for the appraisal. The judge asked Adore how much time they need to formally submit its application requesting for an appraisal. And Adore said, like, oh, maybe a month, but ideally 2 to 3 months. But then the judge actually said that that's actually long. So just submit your relevant materials by July 10. And then the written opinion briefs will be submitted a week after. Now, Danielle's legal team asked that Adore's deadline be shortened to July 8th because they said that the deadline favors the plaintiff. But Adore objected and said that it would not be a sufficient time for them. So the judge just ordered that both sides comply with the July 10 deadline that he set. Okay. Now, the other thing is that the judge was actually trying to accommodate the request of Danielle to try and make this process faster. So he said that the plaintiff or Adore is actually grouping Danielle and the mother together in their claims. So he is requesting that in the next hearing, um, Adore actually separate the mother and Danielle. He said that that will make the case faster. Also, Adore said that one of the key things that's dragging the case is that they are unable to request documentation from foreign companies that Danielle supposedly worked with, like Omega. So they said that without it, then they don't think that the companies will actually comply. So the judge actually sent an email to overseas corporations so that both parties could receive responses. Now, also, Adore said that another thing that's dragging the case is that the defense, that is Danielle's side, is not actually responding point by point to the arguments that they are presenting. they're just doing a blanket denial. So Adore said that if you actually send your arguments point by point, then we can just refute or respond to those points specifically, and that might make the case go faster. Next is the judge talked about the witness testimony because Adore is calling on witnesses in the next trial. And he asked if the witnesses were actually friendly. That means that these witnesses will support what Adore is actually saying, or hostile witnesses will not support what they are saying. And Adore replied and said that they are actually friendly witnesses. So the judge said in that case, then maybe a written statement might already accomplish much of what live testimony would actually provide. And he noted that the case now turns primarily on objective facts rather than subjective opinions, and many of the proposed witness questions were subjective in nature. And he also suggested that the witnesses first submit written testimony, and then the next hearing focusing only on key disputed issues that will genuinely require live examination. According to what they discussed, one witness expressed concern that appearing publicly in court could actually expose her identity and lead to online harassment and bullying. So the judge said that then this proposal would actually help reduce that concern because it would allow us to focus the next hearing on the most significant factual disputes without exposing her identity. Okay, so that is it. The next hearing is going to be a month after now. And when that happens, I'm going to give you an update. If you have any questions, any clarifications, leave them in the comment section below. Also, all the references will be on the description box, so you can just check them yourself if you want that. Just wanted to clarify that much of the what Danielle actually said and what the judge said came from transcriptions of fans of Newjeans that were present in the hearing. Okay, thank you so much. Please visit our website, asianentertainmentandculture.com, asianentertainmentandculture.com. We're trying to boost that up because we want to help more Asian art and Asian artists get exposure in the West. You can also donate to the channel if you want to help. The QR code should be on your screen right now. Also, I do more short form content on TikTok, X, IG, Facebook, YouTube Shorts. So follow me there as well if you want tidbits, news type kind of things, and also shorter. So it's going to be good for you. But I do a live stream for members only. So you can get those, and that does not go public. And you can get access to that if you follow me on, if you subscribe to Patreon or YouTube membership. That is it. Thank you so much. Please like the video, subscribe, and hit that notification button. But the most important thing for you to do is to share the video because that's really going to help my channel. So just send the link to a specific video or off the channel to any family member, friends. Leave a link on your social media, messaging app, everywhere. That will help us. Thank you so much. Till next time.